Go to bigheadsmedia.com for more great podcasts.
Welcome to Dig on America, where we speak truth to power. Every week, we give you the dig on how American history, policies, and media created the social and political issues we face today. DOA is independent media supported by listeners, but they'll tell you we're just fake news, deep state propaganda, funded by George Soros, the Clinton Foundation, BLM Marxists, and
obviously Jar Jar Binks.
Strom Thurmond.
He's been a strong supporter of the show on our Patreon since day one.
Absolutely.
Hello, everybody, and welcome to Dig on America. My name is Mikey Feynman. I'm joined by, you know him as the Pillsbury Doughboy, but around here we just call him Dutch Boy. Listen, Dutch.
Well, hello.
And we also have a new contributor to the channel and the network, Attorney Anna. Hi, Anna.
Hey.
And we have the Dark One. The one who originally ordered those clones on Camino. Matt Delauer.
And I have a 10-step plan on how I'm going to save this republic.
The Supreme Court is in the news. First of all, welcome everybody. Thanks for tuning in and joining in. So we're talking about the Supreme Court and the recent leaked decision that came out, I guess a couple of days ago now, maybe on Monday, discussing Roe versus Wade and basically the Supreme Court potentially overturning that. It has not yet happened as it is a draft, but it looks to be heading that way and in that direction. And before I talk about that, I wanted to kind of discuss the background of Roe versus Wade in general, how it came about, what it is about, and how we even got here. So
can I ask a question first?
Yeah. What's up?
What is it, like they say a draft? What is a draft? Like, what is that from justice to justice? Is that like an email? Like, what is a draft? Like, I don't think a lot of people know what that
it's
is.
the Supreme Court's Yammer page.
they're GeoCities.
They don't have, yeah. So basically, when the Supreme Court is writing an opinion, it goes through different drafts of a process. And what happens is that everybody kind of decides what they want to do. They write their own opinions. They kind of mash them together, create a draft opinion, and then they will all write like supplements to the draft opinion, and sometimes they'll answer other people's arguments in their follow-up on, like, let's just say a second round. They might say, hey, I really like your argument, I agree with that, I'm going to change my mind. They may say, hey, this bolsters whatever I'm saying. So long story short, it goes through a lot of back and forth about what they think their final arguments are, and they kind of sand down, if you will, what the formal opinion should be when it is officially published. So that is the process of it.
So that's what got leaked. Like their rough draft with all their notes on it.
Well, not the notes on it, just the very, very rough draft. So if basically, like, if today you ask me, hey, Anna, what's your opinion on XYZ? And I just gave you my raw opinion without refining what that opinion is, which they do before they publish it, because they might want additional case law to support it, or they might want additional information, or like I said, they might change their minds depending on what the other justices' arguments are. That's really what they're doing in that process. So what happened here was that somebody leaked the very first draft, and the impact of that, one, I guess just in general, it kind of undermines the integrity of the court. It makes it look really political. And I mean, it is an inherently political body because they're political appointees, but it's very rare that their opinions are leaked. Number one, and two, from this point forward, it's going to look like the justices may undermine one another. So let's just say if one justice, let's just say Justice Sotomayor, says, oh, I don't think that there should be, women should have a right to choose. And then let's just say she changes her mind. It might look a little bit differently now that what she originally wrote has been made public, and vice versa. So it's going to be difficult for these justices to change their minds without being subject to substantial public scrutiny. So that's the issue. And like I said, it really just undermines the the privacy of the court and the integrity of the court, because part of the process and them making the decisions is them being able to speak freely to one another to say, I like this argument. I don't like this argument. You make a really good point. That's a really bad point. I want to address that point. I might want to tee this issue up for another issue on another case at another time. All that kind of stuff gets lost when whoever the leaker was leaked the opinion. So that's kind of where we are. Does that make sense?
Yes.
So
Yes.
Okay.
the question I have, Anna, this all got leaked when it was basically in a draft version. At this
Yes.
point, as you were saying, because it's been leaked, there's now massive public scrutiny and appeal that has been drawn to it. And that could then cause an issue where if anybody who in this draft was saying, I'm for this, are now saying that they are not. You know, you could see it being an idea of like, oh, now they're being swayed under the court of public opinion.
Yes.
I guess the question I have is, if this is something that we never saw and this leak never happened, is this something we wouldn't know about in general until they have already pushed to pass what they were going to be voting on?
Yes. So the public doesn't see a Supreme Court opinion until after that whole process. Like, let's just say if the four of us are justices and we all write whatever we think. And then I give it to you, and then I give it to Jason, and I give it to Mikey, and I say, like, this is what I think. And then I read you guys' paper, and I'm like, you know what? Mine might be a bridge too far considering what these other very intelligent people are saying. Let me go back and change my mind. That whole process happens a few times before it ever gets to the public, to where they kind of, tighten up the arguments. They kind of get on the same accord. Sometimes the justices decide that they just want to join somebody else's opinion instead of writing their own, which is called a concurrence, when they write their own opinion, but they ultimately support the underlying conclusion of the majority. Or you might want to write a dissenting opinion where you just say, I don't agree with none of that y'all talking about. Like, I don't agree with none of that. Mm-hmm. So that process has been lost now, because where they would kind of do that jockeying in private, now that has been made public, and everything that they do after this is going to look political if they change their minds. And the whole point of the court is to be kind of free from public scrutiny.
So I guess at this point, then the leak has put it in a place where it feels like the only move that they can make that isn't going to be scrutinized as a political leaning or giving into pressure is essentially scrapping it.
I don't know if either scrapping it, or it might force them to be locked into that opinion. Like, they might just be like, I'm not going to change my mind now, because if I change my mind, everybody's going to be like,
wait.
Changing your mind.
How do you position yourself on either side of the aisle as a fair and impartial judge if your mind cannot be changed by evidence? That makes no sense.
That is rational thought, but we are not living in rational times.
I'm sorry. My mistake.
We're not living in that type of time anymore. And in addition to us not living in that type of time, we would not be privy to this process. You know what I mean? That's what makes the process be able to work without undue influence or outside or external influence. That's the whole point, is that somebody leaked it. So now anything you do after this, if you change your mind, or if you say, you know what, that person made a really good point, like, what does that mean?
Right.
So
this is to me, this is like the idiotic thing about this is religion. They're forcing, conservatives are literally, so much for the Constitution. They're forcing their religion down the throat of people who don't share that religion. And it's all, and the reason why I say it's religion is because this is all about their belief. And if you have this belief, that's fine. Don't force it on other people. But the belief is that sex is for a man and a woman in a monogamous marriage for procreation, generally speaking, 99% of the time. And this is why they oppose birth control. This is why they oppose LGBT. This is why they oppose abortion, because frankly, they view abortion as birth control. And they figure, well, the fear of pregnancy should keep kids from having sex, and it's like, this doesn't have anything to do with them caring about babies' lives. Because if they cared about babies' lives, then they would worry about healthcare. They'd worry about air pollution. They don't care about any of these things.
Climate
They're opposed
change.
to them. They're opposed to them. What they're against is people feeling like, hey, you know what? if I have sex, no problem. I can just run down and have an abortion at Walmart as I'm grabbing some flip-flops. And that's not the way that any of this works. And it's stupid. And they're shoving their religious beliefs down other people's throats. And it's fucking disturbing.
But haven't we always, though? Like the fundamental nature of America is it is a Christian-based democracy. You know what I mean? Like everything that has been done really has been done through the lens and context of Christianity. So, I mean, it just kind of starts there. Like even some of the morals and values that are now codified as law stem from religious belief. So this is not the first, you know what I mean? So it's really not, I mean, it's not shocking because it's like we are in this year 2022 and it's like we should really be past a lot of stuff, especially when we say separation of church and state, but like it's not, you know what I mean? We have a national prayer breakfast, and not saying that that's a bad thing, but it's just like if you're going to tie it to a political party, doesn't that tie it together?
You know, we try to topple monarchies and theocracies across the world and turn them into democracies. And nobody ever says, well, you know, they're a Muslim country, so, you know, they should, they were founded on Muslim principles, so they should have Muslim, you know, a way of running the country that is inherently Islamic. They don't say that. They say, oh, no, turn away from that and become a democracy like me. And it's like, it's, look, and for anyone out there who thinks that the Bible is against abortion, I have news for you. It's not. The verse in Psalms that is generally cited as pro-life is really David complaining about other people not liking him. And the second thing is that the Bible literally advocates for abortion, because in Deuteronomy or Leviticus, I believe.
And 2 Corinthians. Yeah.
In 2 Corinthians, they
said it. Lucius Lion.
Wow. Welcome to the show, Big Haas. But
get it right.
What they do is they say Hasalasa Ding Dong. What they say is, in the Bible, if a man believes that his wife is pregnant and it's not his, they would go to the priest, and the priest would take dust from the floor. And this was a commandment, by the way, to do this, to take dust from the floor, foul dust, and have them drink a bitter potion from it. And if the baby died, then the woman was guilty of adultery, and you would have consequences for that. And if the baby lived, then everything was fine. Last I checked, that is an abortion.
And,
so
okay, Nipsey Hussle. Last time I checked.
I like everything that we're saying, but we're forgetting about the big elephant in the room, which is none of this affects rich people. This only affects poor people, poor women, and women of color. That's who this is. This
in
is
certain states.
That's who this is going to hurt.
Yes. Yeah, the other thing that I was gonna point out was while Dutch brought up the idea that this is imposing religion upon other people, the problem is that religion is a smokescreen, because what it does is it's pushing the idea of those who do not financially have the ability to support a child, whether it was through accident or there is a medical problem or whatever it would be, are now being put in a position where they have to be forced to do so, putting themselves in a lower economic scale now.
Yep.
And just because abortions may be banned in certain states, yes, some of the number is going to go down. But that just means that now, instead of doing it in a medical facility with trained, licensed people who are medical experts, people might try to take things into their own hands, which is what they were doing before, which is why Roe v. Wade got. That's why we did this That's why we did this the first time. That's why we did this the first time. So that's protect the young ladies.
That's an excellent lead-in, and I wanted to talk about Roe v. Wade, because just to kind of give some historical context to just how we got here. So Roe v. Wade happens in the 70s, happens in Texas, and there's a woman who She filed the suit as Jane Roe, obviously for privacy reasons, but her name was Norma McCorvey. She wanted to have an abortion. And at the time in Texas, abortion was legal, but only when the life of the mother was at risk. And her life was not at risk, obviously. So she basically found some lawyers who wanted to challenge this law. And she sued Wade. I forget his first name. I believe it's Henry, but she sues the district attorney, who the district attorney was in fact enforcing this law that women who did not have any health issues should not have been able to access abortion. So it gets appealed all the way up to the Supreme Court, and the Supreme Court says that there's a right to privacy, and that's the important part that I want y'all to remember when we get here. The Supreme Court says that under the 14th Amendment, there is a fundamental right to privacy to make intimate decisions that supersedes the state's rights to ban abortions. And what they did after that was they implemented some rules, and they say during the first trimester, because they try to balance this with the state's interest, up to the first trimester, they say the decision on abortion is entirely up to the mom. During the second trimester, they say states can start to regulate, but they cannot outright ban abortion unless it's to protect the mother's health. So they're saying in some situations, we can make this decision, but you can't ban it all the way. But then in the third trimester, they go ahead and go a little bit further, and they say that states can prohibit abortions to fetuses that would be able to survive outside the womb, except if the mom's health would be impacted in a negative way. And so that's kind of where Roe versus Wade left us in the 70s. But in 1992, we get Planned Parenthood versus Casey, because whenever there's a law or an opinion comes out, you know, there's some wheeling and dealing by the states, and they try to find ways around it. So 1992 rolls around, we get Planned Parenthood versus Casey. And what states had started doing to get around Roe versus Wade was they started implementing roadblocks, aka legal restrictions, that made it harder for women to access abortions in general. So they're like, well, they said we can't ban abortions. We're just going to make it very, very difficult for you to get one. Okay, so the way that they did that was, I think we talked about this earlier, they started implementing spousal consent. So if you were a married woman who wanted an abortion, you had to have your husband's permission to be able to get an abortion. They might, if it was an underage person, or even in some states, women of age, you had to get parental consent before you could even do it. They had restrictions on the type of people who could perform the abortions. I mean, like, yes, doctors, but also they would say you have to be in this type of medical facility, and they have to have this, and they have to have the doors so wide just to get a hospital bed in.
The halls are not wide enough. The halls aren't wide enough. The lights aren't bright enough. So there should have been a quarter inch to the left.
One of the most egregious things that they did to try to restrict abortion was something called informed consent, where basically a woman who wanted to have an abortion had to go to her doctor first, say, hey, doc, I'm trying to get an abortion. I don't want this kid. And then the doctor had to give her very, very specific information and literature to at least 24 hours before the procedure was going to take place, that was supposed to tell this woman how an abortion was going to be detrimental to her mental health, and talk about the viability of a fetus, and basically all these things that try to induce a woman into changing her mind about this decision. And so that was the issue in Planned Parenthood versus Casey, all these restrictions. They also try to change what the definition of a medical emergency was, because remember I said in Roe versus Wade, if the health of a woman or her life is impacted by this pregnancy, then they would make certain exceptions for that. So this case goes up, Casey versus Planned Parenthood goes up to the Supreme Court, and in a 5-4 decision, and the reason I say I'll get back to why I say 5-4 is important, but the court affirms Roe versus Wade, and they say that restrictions, these type of restrictions, the ones I just went through, are unconstitutional because they place an undue burden on a woman's right to get an abortion. Remember, we're underlining the right to privacy to make intimate decisions as the standard. The reason that 5-4 decision is so important, and usually the way that the court decides, is because 5-4 indicates that this really could have gone either way. Right. And that kind of opens the door for somebody to try it again with maybe another court makeup like we have now, where in that case, it may have been a liberal court today we have a more conservative leaning court. And in that situation, it's not anything for me to just bring it up again. And maybe some different folks are going to decide it a different way, which according to this draft is kind of what happened. So in this particular case, and I know we talked a little bit about how the drafts get exchanged. So as of now, abortion is still legal. There is still, as of now, a fundamental right to privacy for women to be able to access abortions. And there are certain things that states can do as of now. But when we see this draft, the draft kind of gives us insight into what the court may be thinking, what kind of legal considerations that they're looking at, and what their analysis is going to be in this outcome, which is ultimately that there is no protection for abortion. Another thing to know before I really get into the facts of the case is that this case was rejected at both the federal district court level and on the appellate court level, which means that the Supreme Court decided to take it on its own. It's not like two courts came out with different decisions. It's not like they filed the suit in federal district court and then appealed it and got a different decision. They lost at both junctures, went into the Supreme Court, and this draft suggests that they just completely ignored the lower courts. I mean, they did. So anyway, so this case starts, it's called Dobbs versus Jackson Women's Health. So 2018, Mississippi passed a law called the Gestational Age Act, which essentially prohibited all abortions with a few exceptions after 15 weeks gestational age. 2018 is important because obviously that's when Trump was in, and a lot of states, especially certain southern states, were teeing this issue up for the Supreme Court in the event that there was a conservative majority. So basically, if the Supreme Court says something is unconstitutional, you can't do that, but I'm going to do this. And that's what Mississippi did. They did something different. So now we have to get the issue back into court again. So that's what's going on here. So anyway, they passed this Gestational Age Act, prohibits all abortion except after 15 weeks. And Jackson Women's Health Organization, the only licensed abortion facility in Mississippi, there was just one. And one of its doctors filed a lawsuit in federal district court challenging that law and requesting an emergency temporary restraining order, which is basically injunctive relief, saying, hey, judge, this law is crazy. We don't think it's right. We are requesting that we hold everything in place up until we can get an official ruling on that. So basically, please let us keep doing abortions until the courts have decided what they're going to do about this.
So real quick. You said that was the last place in Mississippi.
It was the very last abortion facility licensed.
Yeah. I just looked it up. There's 3 million people that live in Mississippi.
Yes, I mean, so one abortion facility for an entire state is really really amazing.
So if we break down the numbers here, let's say half of the population is female. And let's say another half of that, you're talking about 750,000 people that have to use the same facility?
Yeah, the same facility, if they even get it. I mean, Mississippi is one of the more poor states in the country. Right. And it's rural, and that's not a dig at Mississippi. It just is a fact. And it's unfortunate because the impact of that law, while on its face might be neutral, is that realistically, women are not going to get abortions. You banned it without banning it by only letting this one place do it, and then saying even this place has to go through extreme restrictions to be able to do what they do in the first place. So yes, problematic.
Yeah, pushing for, make an appointment now because there's a 6-month waiting list to get an abortion.
Exactly. So basically, if you think you might be pregnant next year, make your appointment today. That's what they do.
Which by the way, don't think they haven't thought of this, because then they get to change the conversation to late-term abortion, because now they're going to say, oh, look, Democrats who already love abortion, like they think that Democrats go to the abortion clinic and just sit outside and grab popcorn and watch. Oh, I want to watch some babies be aborted today. They really believe that we like love abortion. They're going to, this is going to be to change that conversation to say, look, all these women having 6, 7, 8, 9 months abortions, 14-month abortion, which obviously doesn't exist, but they'll use that in the narrative because it's more polarizing to Joe Schmo in the middle who's not paying attention.
I mean, but the narrative was always there. I mean, this is not these series of lawsuit abortion ever since Roe versus Wade and Planned Parenthood versus Casey. There have been consistent attacks on this right to privacy since that time. Like, it's not like this just came out of thin air and nobody thought anything of it. And they were just like, you know what? Trump is in office. This is a great time for us to challenge abortion. Nobody did that. They have been plotting on the day that they got the majority in the court to be able to do this. And the only way that you can make an issue ripe for a court's review is to actually pass and implement laws to challenge that. So like I said, they couldn't do certain restrictions because that was banned by Casey versus Planned Parenthood. They couldn't outright ban it because of the right to privacy under the 14th Amendment under Roe versus Wade. But what they can do, what they did, is they make it so there's one facility. And in that one facility, you only get up to 14 weeks. So now let's talk about that. And that's the very narrow issue that gets this entire thing back to the Supreme Court. So every state now, and if I'm not mistaken, there's, I want to say between 8 to 10 states who, if this draft opinion ends up becoming a finalized opinion, abortion will become immediately illegal in those states. Like 13, upon the decision.
Trigger law states.
Sorry.
I think it's 13 trigger law states where it's
yeah, of course. Yes. So they have been writing legislation for this moment, for this day. When Trump told these people he was going to get them a majority on the Supreme Court, and then he did this, that was the time. You was like, this is my time. Like, you're not gonna miss your beat. They were ready for this moment. Like, you had to be prepared for that because it's been 1992. It's been 30 years. They've been waiting on that.
Yeah, but first of all, I'm not going to push this into Trump land because had Trump not been president and another Republican was president, McConnell was still going to do the same thing. We still were going to get, if Ted Cruz were president, this would still be a problem. This has nothing to do with Trump.
I mean, whoever. I just used Trump to say he delivered these justices to these people, and he. Yeah,
I'm not giving him a win on this. No, I see what you're saying, but like he's going to take the credit for this. The fact of the matter is, and that's the thing, is Republicans say, look, this is another win for Trump. Not really, because if Ted Cruz or Marco Rubio had won, RBG would still have died. Right?
I think she should have stepped down a long time ago.
Absolutely, but separate conversation.
Yes, a different conversation.
She would have died. They still would have talked what's his face into stepping down, and McConnell had already pushed off the Merrick Garland nomination well before Trump was actually given the nomination.
Yeah. Well, whatever it is, whoever the president was, and like I said, I just used Trump because he was the president. Whoever it was, they did it. You know what I mean? Their efforts were successful. So it don't even matter who did it or how they did it. The fact of the matter is they got their people on the court. And now we here looking at the draft opinion like, oh shoot, what do we do?
This is Mitch McConnell. This is Mitch McConnell's big win, right? Like it's like he's the asshole behind all of this. And
it's not just him. Do not make that mistake. It is not just Mitch McConnell. This is bigger than Mitch McConnell. You know what I mean? This whole thing is like, this is a culmination of so many social issues, cultural issues. Sure. Like this whole thing has been brewing, like, not to say that because, he is old AF. He has been in power a very, very long time, but the movement was really bigger than him. The movement was about as soon as Roe versus Wade and then Casey versus Planned Parenthood, as soon as that happened, those were the triggers for that, because immediately people were trying to figure out what they could do. Like I said, that's why Casey even came out, because once that happened, they had to do something to challenge it again, which was impose certain restrictions.
What is next?
Which mean what's next?
No, tell us what is next. Like what should we expect in the coming days and weeks?
Oh, so the leak of a Supreme Court opinion is unprecedented. I'm not sure the impact, the greater social impact of how this will play out. Like riots, protests, law changes. I don't know what Congress will do. I don't know what anybody will do. I do know that we're supposed to be expecting the published official decision in or about June or July. And just to give some background, I believe this case was argued in December, and they didn't even write that first draft until February. So that should tell you how long it takes for them to go over their arguments and to refine their arguments and to think about what they're actually going to say once they bounce these ideas off of one another.
They bullshitting. It don't take you 4 months to read some shit. Nah, man. They're over there chilling. They going on vacation. They on trips. They chilling.
What happens is that they have their clerks research certain discrete issues. And when you research it, when you make a Supreme Court opinion, you basically have to have these people read everything, because you don't, in the courts, we have something called stare decisis, which is mean it's already been decided. We're not going to overturn law. So if you are justice trying to overturn a law, you need to find as much legal support for your position as possible. And if you're the person who's trying to uphold the status quo, then you need to come with as much case law as possible to be like, this is why we cannot change it. Which is, what is supposed to be, what was supposed to be happening before the leak. Anyways, let me just get back to the facts of this case, and then I'll get back to.
Can I ask one question real quick?
Sure.
What credence do you give to the reporting that by leaking this draft, that the justices are kind of locked into their decision and they can't change their mind in the interim before the final draft comes out?
See, this why we've been on time. I'm just kidding. I'll say it again. But long story short, I don't know. I don't know. I'm just kidding. I'm just messing with you.
No, it's fine. It's fine. I was working.
Hey, that's why you're replacing him. And did we let that out?
Listen, no. He has a job. He's at work. Listen, you cannot hate on nobody that's at work.
Stirring the pot. Always stirring the pot.
You can't hate on nobody that was at work. So listen.
Trying to tear down this black man.
No.
It's always them damn
man. He always tearing
napkins,
down the black man.
Always them white liberals.
Black man can't do nothing right today.
Hey, you know what Martin Luther King said about the white moderate? Martin Luther Jr. King.
Y'all remember what Morgan Freeman King said about it?
let Attorney Anna get back.
I'm not going to play with y'all. But to answer your question, I don't know if this will impact their decisions. I can't help but to think that it will, because they are already seeing the impact of what their initial thoughts about this is. I think that type of public pushback has to creep into their minds. But at the same time, if you're a justice, you still have an obligation to do what you think is right. So I do think that there's still, and just by the way that Justice John Roberts is moving, trying to find the leaker, doing this investigation, trying to proceed with things as if this had never happened, I think that they're still going to go through the process of trying to finalize and refine what it is. But I think that when that happens, people are going to look at that first draft and the last draft and be like, depending on what's said and who said it. So I think that might be it. And it might put pressure. It's not going to be a unanimous court at all, but it might put pressure on the other conservatives to not issue their own opinion and just join the majority opinion. Like, they might not want to say anything that's too far out of the way for fear of public scrutiny. And I think that does the court a disservice. Whether I agree with the opinion or not, I think it kind of interrupts the integrity of the court. So
thank you for that reiteration. I'm sorry.
Yeah, no, it's all good. You was at work, okay. But just to kind of go back to this case, so we have this one place in Mississippi, and they're basically implement this law that says that basically all abortions are banned except after 15 weeks. The only one licensed facility in Mississippi challenges this law. They get a temporary restraining order to allow them to perform abortions while this is going on. And the district court actually prevented Mississippi from enforcing the law, specifically finding that the state had not provided evidence that the fetus would be viable at 15 weeks, and that the Supreme Court precedent of Roe versus Wade and Casey versus Planned Parenthood prohibited them from banning abortion prior to viability. And so remember when I was just describing stare decisis, the district court in Mississippi basically was like, look, the Supreme Court has already said if the fetus is not viable outside of the womb, abortion is legal. Y'all cannot put this 15 weeks on it and try to wrap it up and say that it's something different, because it's not. So they appealed this to the Fifth Circuit, and the Fifth Circuit affirms the lower court. They say, hey, the Supreme Court has already spoken about it. I don't even know why y'all brought this to me. We already talked about it. We already said no. The Supreme Court took it anyway. They appealed to the Supreme Court, and the Supreme Court took it, which says a lot, because the Supreme Court doesn't even so many people appeal to the Supreme Court for cases, and they only take a handful every term. So the fact that they even took this case meant that they wanted to reconsider this issue, which is flag number one on kind of where the court was leaning. The fact that they even wanted to discuss this issue and opine as to what should happen. So anyway, the draft opinion in its current state explicitly overrules Roe and Casey. And this is the justification. They say that there is no reference to abortion in the Constitution, and thus it is not a protected right. They also say that access to abortion or rights to abortion is not rooted in history. And so that kind of brings about the issue from Casey and Roe, which is the right of a person to make private, intimate decisions, like whether you take birth control, whether you are entering into a gay marriage, whether you're entering into an interracial marriage or whatever. And the way that they try to distinguish that is by saying, this is different than those things because this involves a human life potentially, and those things don't. So this is different. But really what they're saying is that there is no right to privacy as it is concerned to anything that is relating to a fetus. But interestingly, other things that are not in the Constitution are concepts like executive privilege, qualified immunity, presumption of innocence. Those things are not in the Constitution either, but we have Supreme Court precedent that establishes those legal constructs. So in short, this draft opinion is so problematic because once you start saying this right to abortion is not a right to privacy, then it begs the question, other cases that were decided on right to privacy, like I just mentioned, interracial relationships, gay marriage, birth control, contraceptives, all that kind of leaves the door open to say those are not fundamentally protected rights to privacy either. And you can change, and that means that if another state, let's just say, decided they're like, well, we don't want to ban gay marriages. We only want to ban gay marriages where they haven't been living in a house together longer than a year. Then what? You know what I mean? That's kind of what it opens the door to. So, and just as an overview, like a bird's eye view, what this means is that there's no federal right to abortion. That's what this draft opinion would say. And states cannot go below a federal minimum. So whatever the federal, let's just say, or Supreme Court says, states can't go below that, but they can go above it. So the below, or the bottom in this case is the Supreme Court saying there's no right to abortion, which means that if a state like New Jersey, where I am, wants to allow women to have the right to abortion, they're free to do that. But if a state like Mississippi, like y'all not getting abortions, they're free to do that too. So that is really the problem. If you have means, you will be able to leave your state if they, implement it and get an abortion. But if you do not have means, you are forced birth.
Hey, if you have means, they will come to your come to your house and do it there
and make it your house will temporarily be part of Canada because they'll give you diplomatic immunity.
It's actually difficult because for me, I think it's a personal decision, and I think if someone does not want to have an abortion, don't have an abortion. Have your baby and be happy. Right. But at the moment that you start telling me what to do, especially when you gonna tell me that you don't want to wear a mask because your body, your choice. Because I feel like a lot of these people are the same people, and that's the difficult part for me is, you know, and a lot of people, and I actually watched today these I guess they're like prankster reporters, I don't know what you would call them, but they went to a Right to Life rally or march or whatever it was, and they had all these signs up about adoption, like being a viable alternative to abortion. None of the people that they interview had adopted any kids.
They never. I'm
not saying that you have, and I'm not saying that that's not an option, but it's just like, how are you going to make somebody have a baby and then make them get a baby away, and then you wouldn't even take the baby? Like, you're not even going to take the kid.
Standard.
Yeah. Jordan Klepper
operating procedure.
Jordan Klepper had a amazing video on that where he was walking around to all the people who said at the abortion. He asked like 60 of them. They were like, "Oh no, I never got the chance to adopt. I have 4 of my own. I have more of my own." Come on.
Same video. Yeah. Y'all not taking the kids, like, and then y'all want me to do what? Drop them, pay for them with the money that you don't want to give me because you don't want to raise the minimum wage. And then you want me to educate them with what? In the state that is 49th out of 50th in education. So who do y'all want these people to be exactly?
Yeah, and not give them health care. So, I mean, they would have an argument maybe if they were like, hey, let's give all children health care. But no, they don't want to do that because they don't care.
Because the parent might accidentally get health care.
Yeah.
Oh my God.
Can't have that.
You accidentally save your life.
I tell you, these pro-birth people, because it's not pro-life.
No.
As soon as the baby is born, they think of every way they can to take funding and quality of life away. So
yep.
I know you feel like you're too poor to have this baby, but we're gonna make you have it, and then we're gonna look down our nose at you for being in an economic status you're in, and then say, why you keep having babies?
That's not true, Haas. All lives matter, Haas.
Yeah, I could have sworn.
There are so many refugee kids here right now, especially from the Ukraine, and especially from before.
If you're from the Ukraine, it's all good.
No,
but you better not be from Haiti
or Afghanistan. Because we were taking refugees from Afghanistan last summer.
And they were pissed off about that.
No, everyone was very happy and welcoming. I remember that specifically. Also, the kids on the southern border, they are treated. It's like a holiday for them.
Right.
In fucking cages.
Icebox rooms. Because they ate that trek in the heat. So we put them in the refrigerator rooms to cool them down because it was so hot on
the fact that the fucking kids have the fucking foil fucking blankets for like emergencies lets you know all you need to fucking know.
Look, it was all justified because there was Muslim terrorists in the caravan. So
there you go.
There was one. There was one.
Yeah, there was 0. No, but it was proven there was thousands.
Millions.
All right.
And they voted in the last election.
Anna, let's give Anna center stage again for a second here before we let her get back to her life. So, listeners, welcome Attorney Anna to Dig on America. She is now a permanent fixture here. And
I don't know. Do we clap? I don't know how to do.
Yeah. So we're happy to have.
Oh yeah. I like the snaps. Good call.
Anna's going to have her own show on the network. We're thinking a few weeks.
I am going to have my own show. Yep. We're going to figure out what we going to talk about though on the show.
You got to name it still. You still have to name it. But
it's unfortunate. It's really a disservice to women everywhere. It is fascinating that men continue and have always thought that they have the right to the autonomy of a woman's body. And this is just a continuation of that, in my opinion. And it's unfortunate. It really is unfortunate because the people who we entrust to preserve these rights and also to follow precedent, they did not do that. And in fact, the thing to me, and not, because I kind of follow the confirmation hearings, Coney Barrett and Justice Kavanaugh sat up and told a legislative body that Roe versus Wade and Casey versus Planned Parenthood were codified law, and it was settled. They considered it to be settled law. And that was part and parcel of the basis of their confirmation period, which means they got on the court by lying.
Yeah.
Which means to me, Democrats, y'all need to start getting up in there in line. So if y'all got to say, we just going to get rid of abortion and get rid of abortion your way to the Supreme Court and pull a okie doke, that's what it sounds like we're going to have to do.
In fact,
I just don't.
Better than that, if you're a Democrat and you're a judge and you're a lawyer, pretend you're a right winger, be as extreme as you can possibly be, talk about the space lasers and everything. And then as soon as you get to the Supreme Court,
change your mind.
Yeah, change your mind and turn into RGB2.
But from a legal perspective, it basically if this draft were to go, because again, emphasis on the fact that it's a draft. If the draft continues, that basically gives the court, whoever is on the court, whenever and at some indeterminate time in the future, that they do not have to follow precedent. And that's the biggest thing that we have in law, is that everything that we do today is based on what we said yesterday. Everything that we do. So when we sit down to write something, I have to say, here, judge, they said it here, they said it here, they said it in this situation, they said it in that situation, they said it with a red hat, they said it with a blue hat, they said it in every single situation. So this is why you should do it this way again. And usually if somebody wants to do it another way, you have to make damn sure that you have a great reason to go against all the history of precedent that we have to overturn that decision. And this draft shows that the Supreme Court completely disregarded at least 50 years of stare decisis. In fact, again, that the current justices said that they would not disturb. So that's my biggest gripe about it.
Should we start swearing them in? Because they're
Swearing
not
them in
when they go in front of the Senate. Should we start swearing them in first so that they're?
When you are talking to that body, I mean, I don't even know if you are sworn in. I presume that you are. I don't think that you have to take an oath.
They're not under oath.
I mean, but it's just like you have to do so many things to be a lawyer, and then you have to do so many more things to be a judge, and then you have to do so many more things to be the type of judges that they are, that we don't expect that you're not a liar. You know what I mean? Maybe we could, but it's like, if it's a lifetime appointment, what's the penalty if you lie? We're going to remove you?
Yeah.
That's political. We can't just start removing people. We can't just start. See, but that would be very problematic, because we can't just pull you off the bench because you disagree with, you changed your mind, because that's what they're doing right now, sitting up in a room and changing their minds about stuff based on better arguments.
But
you know what I mean?
Prove that, but if I can prove that you.
But what if I change my mind though?
But you change your mind only for the hearing. You only change your mind for the hearing, and you change it right back.
I mean, but what if I decide? What if I thought in that hearing that?
Ooh, you're roboting on us pretty hard.
What if I decided though?
Hold on. Just give it a second. Just give it a second.
Okay.
We'll let it calm down, because we can't hear anything you're saying.
There we go. All right.
There we go.
Okay. I was saying, what if at the time of my confirmation, I truly believe that this is settled law, but then my clerk gives me a whole bunch of case law saying this is not settled law. There is no right to privacy. The Constitution doesn't mention abortion, and it's different with a life. And I've got all the circuit splits from all the different federal courts. Now I have an enlightened reason to change my mind. What in that case?
If you were anti before, you suddenly become neutral, and then you go right back to anti. No, I'm not buying it. That's
from a practical perspective, but to go back to what you said, I don't think it would help to swear them in, because it's basically being like, you basically would be making them commit perjury. Like, you know what I'm saying? Which would be a crime, which would be problematic, because then, because of the political nature of the court, we could be like, you are a criminal, we're going to remove you for being a criminal, but really it's because we as a legislative body don't like your opinion. Like, you still have to, these businesses are jacked up, you still have to make sure to safeguard the integrity of the court. You know what I mean? Like there's still a body that has the integrity of which has to be preserved, even if the people in it are jacked up, just like Congress. Like there are things that I'm not going to say have to do, should do in Congress. But if Congress, the body is only as good as the people that serve it.
So a question I have, Anna, if you wind up being under oath in a situation where you are speaking in court, and it is something that whatever you're speaking to is based in either your opinion or what you believe to be true at the time based on the information you have, is that still considered perjury if what you have said is technically not correct?
No, because it's your understanding at the time that you said it, as long as you make clear that that is your understanding at the time. Because if I ask you later, oh, was the light, well, maybe not the light, but now maybe let's just say that you, between the time that you testified and the time that we asked you again, you talked to somebody and got some information, and now you know what you said wasn't true before. It's not that you lied. It's just that you did not have as many facts as you now have to support the conclusion or opinion that you had the second time.
So if they had to swear in front of the Senate and speak what they know or believe to be true at the time, then wouldn't that be a situation where we're not forcing anyone to perjure themselves as long as they themselves are not choosing to lie under oath?
But the problem is putting the justices under oath, because the implication of perjury is that they're going to be subject to criminal penalty, right? Like that's the only thing that comes from perjury, is that I'm calling you a liar and you lied illegally. At the moment that you start doing that to the justices, I mean, you kind of have to balance that with the fact that they have lifetime appointments. You know what I mean? And then like you can't basically have them on a rope and yank them back because something they did or said in their professional capacity did not comport with their understanding before they were in that body. Because maybe two of the justices, let's just say using RBG and Scalia, since they both did, maybe they both talked and they're on opposite sides of the spectrum. But let's just say Scalia changed his mind about something he said in his confirmation because he talked to RBG, who is also an equally intelligent person, right? Are we going to say he's a liar and put him in jail or yank him off the court? We shouldn't. Because
but I would say at that same time, as long as it is understood that it is ultimately by gaining more information, he has changed what is essentially an opinion,
right?
Then no, he has never actually lied.
But all of it is an opinion. Like even the article, the document that they put out is called an opinion. You know what I mean? All of it is what they believe to be true. None of this is none of this is fact-based. This is all what these people think is right at the time that they decided. So it's never really that they're lying about facts. What it would be is that your opinion now versus your opinion at a later time in the future, but we can't say that your opinion is ever subject to criminal penalty.
Anna, I just want to hold their damn toes to the fire so that they don't get up there and grandstand and lie, get the gig and like, let me pull out that Klan mask real quick. Like, let me get that hood out. There should be, but you're saying, and also I don't think there should be lifetime appointments anyway.
So the thing is that there is a way, but is it practical? No. The Congress in its legislative authority can remove justices from the bench. But the thing is are you going to get and that's the check on the judiciary. Are you going to get the entire Congress to agree that we should all remove this person? Because we can do it. We can all say, if we're Congress, we can all say, you know what, let's take him off the court. He lied. But we have to all be able to say that. Not all, there has to be a certain majority, but there is a check on that. It's just we're not going to who's going to do it?
We need a new constitution. I'm done.
I mean, in all honesty, Mikey, you don't even truly need to lie about things to get to become a justice. You can sit up there and cry and talk about how much you love beer, and you can become a fucking Supreme Court justice.
How many kids you adopted? Amy Coney Barrett, it was never even a trial attorney. And it's funny because I was talking to one of my partners at my firm about what the if there should be minimum qualifications for the bench. Should they have trial experience? Should they have been a federal judge? Is it okay for them to be a state Supreme Court judge? I don't know. But that whole inquiry is the subject of confirmation hearings, period. That's why they have them. So everybody can see, is this person qualified and or fit to be a servant on the highest court in the land? And Congress, in its infinite wisdom, is supposed to decide for us because we elected them. And so that means we elected them and they chose them.
Dutch, write this down. We need to do a dig on the Supreme Court.
Done. I
And
just
then we'll have
finished
Anna,
it.
but we'll only do it when Anna is available. So don't make it fucking next week or some shit. And make me fucking answer that. I don't know.
I was thinking that we were bringing Anna on to the show as a contributor. It seems to me like we've found like she's already the CEO. So
yes, CEO. It's giving Rihanna. Love that. Thank y'all. But I had texted Jason this Twitter thread about who might have been the leaker. And basically initially, and I think a lot of people thought that it was just this angry liberal person who was trying to incite all these riots and what have you.
Mm-hmm.
Jason, if you don't mind, you can put the link in the comments to it. But a person who used to be a Supreme Court clerk. Sorry. A person who used to be a Supreme Court clerk was discussing the timing of it and what it would actually do. And that person seemed to suggest that, like to what you were saying, House, that maybe the goal was to try to lock them into certain opinions, the rough draft opinions. And if you have an extremist ideology about it, maybe you don't want the court to change their mind about it. So it could be that the person is actually a conservative who just wants to limit how much willing and dealing that the court is going to do. So I thought that was a really interesting perspective as well.
It's interesting that we're talking about willing and dealing in the Supreme Court, where it's supposed to be,
When I say willing and dealing, I mean the free exchange of opinion. I like to use colloquialisms. I do not mean negotiating or bargaining. I just mean the free exchange of legal opinions.
The problem is, Haas, I've got these tickets that go to Paris for the weekend, and I might not be able to use them if somebody else decides they want to vote the way I'm voting.
Right. The French Riviera.
Yeah,
nice this time of year.
I might suddenly come down with something, and I can't leave the country that way.
I got a Rona scare. I'm gonna have to be in the house. Right. That's crazy.
I'm scheduled to have shingles.
Yes. This is my Instagram. People can't see this, but this is the person basically is saying why she thinks that the person may be a conservative fanatical person. That is her word, not my word, but you don't have to go through the whole thing because it's really long. But they basically were like, what would be the implications of someone who is a conservative versus someone who is a liberal? And a person who is a liberal who would have leaked it, if they are found out, would probably face a lot more scrutiny than somebody who is a conservative who leaked it, because they might just be like, well, I mean, they've been leaking all kind of other stuff. Justice Roberts' wife was part and parcel of the insurrection, and ain't nobody said a thing.
Thomas.
So you mean Thomas's?
Who I said?
You said Roberts.
Oh, sorry. I meant the worst Justice Thomas.
Oh,
but
God,
that's just racist.
Steven from Django, motherfucker.
Justice Thomas is another. His life is actually very interesting. He benefits from affirmative action. Let me just leave it at that. But anyway, this person seems to suggest that there would really be more of a reward doing a cost-benefit analysis, that there will be less of a risk and more of a reward for a conservative person to have leaked this than for a more liberal-leaning person to have leaked this. And they also talk about who the people are that are clerks, and the liberal people who are clerks are not usually fanatically liberal. They're more follow the rules, follow the law, etc. type of liberal people. That's how they even get on the court, because they want to get to be clerks, because a lot of them want to appear to be balanced.
By the way, this wasn't a tweet that you sent me; it was a novel. But it
was good. PDF of a miniseries.
With what Anna described, like, it makes a whole lot of sense. It's basically the idea of, now that I have shown this to the world, you have to maintain the position that you've already had. Because if someone who was liberal leaning leaked this, the reason they would leak it is basically being like, I want to force public opinion to change the way that they're going to vote. At which point, as we said, that's going to just be seen as falling under political strain because you don't want to look bad in the fact that you voted against Roe v. Wade.
Right?
Yes. Very well said. That I think that's exactly it, is that they were trying to force the hand of the court